the right of appeal being substantive should not be marred or should not be reduced by such technicalities, and therefore for the CITA the power has also been given to CITA that by following the Rule 46A, by adhering to Rule 46A contents and by procedure, learned CITA may decide to admit the additional evidences. And in a nutshell, the Rule 46A is surrounding around the circumstances when the SSC could show that there were sufficient reasons that he could not file the evidences, or the evidences have come out after the assessment proceedings were over. But at the same time, before admitting the additional evidences, in that case, learned CITA will ask the SSC to file two sets of the additional evidences. So one set will go to the learned AO, and learned AO will be entitled to offer his comments after verifying. For verifying, he may once again call the SSC also, and after verification, once the comments have come, thereafter the CITA proceedings will resume. If in a given situation learned CITA decides not to admit the additional evidences, then that also can become a subject matter of appeal, a ground of appeal before the Honorable Tribunal. Coming to Honorable Tribunal, to get the additional evidences admitted will be very, very difficult, because even the rule, ITAT rules, provides that it is the domain of Honorable ITAT to decide whether additional evidence is required or not. So per se, there is no right given to the SSC to submit the additional evidence. But then the rule has been logically interpreted that it can also happen that the SSC submits some additional evidences, and then Honorable Tribunal may take a view that these evidences are necessary for granting substantive justice. But at that time, the SSC will have to prove why he could not produce the evidence at assessment level, then why further he could not produce these evidences at CITA level also. So there is certainly a difficulty on the part of the SSC to get the additional evidences admitted unless he can prove the circumstances why the evidences could not be proved, and the Honorable Tribunal has to come to a view that these are the evidences which go to the root of the matters, and therefore these evidences must be advanced. But if the evidences are totally bringing out a new point, with the result that even the grounds of the appeal also will change, then the Honorable Tribunal may take a contrary view that these evidences are not admissible because they are totally changing the subject matter of the appeal also. So these are my brief views. I know that constraint of time, I may be missing out some point, but we have very authority here only to complement और सप्लीमेंट और मॉडरेट माई व्यूज.
नहीं GHIA साहब बिल्कुल नॉट एट ऑल. साहब इसमें एक चीज़ मेरे को थोड़ी सी आप बता दीजिए इसमें. और यू सी ट्राइब्यूनल में है नाउ, इन द ट्राइब्यूनल देयर मे बी टू फॉर्म्स ऑफ एडिशनल एविडेंसेस व्हिच may come for. One, I was not able to get the bank account, and now I have been able to get the bank account, and that bank account proves my cash credit. Can I not then, as a matter of right, say, sir, I invoke your jurisdiction, this is something which I could not have concocted, please accept it. This is one instance where it is by a statutory authority. The other is that I say, sir, in order to substantiate my point, I am getting a certificate of a chartered accountant to certify this particular issue. Kindly accept it. Those two forms of evidences, how would you distinguish, besides, of course, the issue?
The first thing is, any evidence or additional evidence, they has to be restricted to the grounds of appeal raised, because the tribunal has jurisdiction to adjudicate the grounds of appeal raised before it. So therefore the question of furnishing any additional evidence which are beyond the grounds of appeal may not and should not arise. Now coming to the admission of the additional evidence, naturally first SSC has to bring his case within the ambit of Rule 29, which gives the details in what circumstances additional evidence can be admitted by the tribunal. After the additional evidence is admitted, ordinarily the matter is set aside to the file of assessing officer, because it is a settled position of rule of natural justice कि other party, namely the department, has to be given an opportunity of examining those evidence. By furnishing the evidence for the first time before tribunal, the revenue cannot be deprived of examining those evidence. Therefore, two options are open to ITAT: either call for the remand report from the AO or set aside the matter back to the file of AO so as to re-adjudicate the matter in the light of those evidences. Now, the question put by Mr. Wadhwa is कि if there are some additional evidence in a form which need not be examined, say it is a bank account, assessing officer call for the bank account which cannot be produced by the before the AO but produced before the tribunal. So if additional evidence is of such nature which does not require any examination, but still the thing would be the re-examination of the entire matter in the light of that additional evidence. Say it is a matter of cash credit. So the bank account is only one aspect of it. So normally whenever additional evidences are admitted at the stage of the tribunal, the likelihood of matter being set aside to the file of AO is much.
I understand. Thank you, sir. Thank you very much, sir. Now I come to additional grounds. You see, very often it happens that the legal requirement is that whatever issue we challenge, decided by the CIT appeal, we have to file grounds of appeal. And the tribunal would only confine itself to the grounds raised in appeal and nothing more. But we find that, well, certain grounds have been omitted. Now, can we take up those grounds by way of additional grounds before the CIT appeal or before the tribunal? Under what circumstances? What form of additional grounds? Mr. GHIA, if you would throw some light on this.
Mr. GHIA, before you take up, I would add one thing. Say, in while discussing last question, you said कि if there are some evidences which require the modification of the ground, that you may cover here. कि if later on you find some evidence with regard to some ground, though you did not take up before the lower authorities, but now because of those evidences you can take up. So then first course would be to take the additional ground, and then after admission of those additional ground, then perhaps the additional evidence. Please.
Sir, thank you very much, sir. I would distinguish the powers of learned CITA versus Honorable Tribunal in the context of additional evidence, additional grounds like this. That while the scope of subject matter for the CITA is the scope of the subject matter as it was at the time of assessment. So the powers of CITA being co-terminus or co-extensive with AO, there should not be any problem for the CITA to admit any new ground of appeal. And particularly when the no new evidence is required, no new facts are required, the CITA can certainly admit the ground as may be amended by the SSC also. When it comes to Honorable Tribunal, the Honorable Tribunal's powers are the subject matter would be the scope of the appeal. So far as the new ground is falling within the scope of the appeal, to that extent Honorable Tribunal can certainly admit the grounds. But at both the levels, the grounds are to be first brought to the honorable authorities, and then only after they are being permitted, they can be raised, they can be added also. When it comes to decision, the Supreme Court has very categorically in Saporji Palanji 44 ITR 891 distinguished that CIT's powers are co-terminus and therefore all the additional grounds can be admitted. As sir rightly guided me, that when the new evidences are produced, and if ultimately the new evidences have been admitted, then certainly that may become addition or amendment to the grounds of appeal. So that will be something like a natural corollary, that if the facts are changing, then the grounds of appeal also may change. To add to that, sir, I also will like to mention for your kind consideration that after I have drafted the ground, there may be some amendment in the law, there may be some further judgments coming, and therefore also my grounds of appeal may change sometimes, and that will be for the authorities or Honorable Tribunal. But ultimately, if the facts are already there, in general one can say new ground will be certainly admitted.
Sir, anything you like
Yes.
to supplement?
No. The settled legal position is कि when there is a when the SSC raises the additional ground, which is a legal one, and with regard to such grounds, the facts are already on the record, then normally such additional grounds are admitted.
Yes, perfectly. And the judgment, I would just cite, this is what the ratio of the judgment which Shri Agarwal has said, is NTPC 229 ITR 383 Supreme Court. This is what the judgment says. Now, sir, if I may just now state that we are ready to take the questions.
If they come
we will
up, we can
continue. If
take-
they come, we
yes.
will continue with our debate.
Yes,
and
yes.
whoever wishes to raise a question,
They
we
can
are
come in
prepared.
between.
They can come
Yes,
now.
yes.
Okay.
Fine,
So,
fine,
okay. Now, sir, I want to take up one issue which bothers me and bothers a large number of people across the spectrum is that there is a judicial hierarchy, and the judicial hierarchy is Supreme Court's judgment are binding on all, High Court is binding on the jurisdiction where the High Court is situated, Tribunal, CIT appeal, and of course, assessing officer doesn't come into the picture here. Now, very often we find when we cite a decision of a tribunal before the CIT appeal and say, well, this is the law which they have expounded, they are loath to following that. They say, well, it is only the tribunal, the High Court has still to decide, or we will not follow the jurisdictional tribunal, we will go and follow some High Court judgment. What is the remedy available in such a case? And what is the sanctity of a higher authority's order if they are not to be followed by the lower authorities? Yes, sir. Let's tackle this issue first and then we come to the others.
Ajay, I think your question includes two parts. One is what is the law of precedence, and secondly, to what extent the binding force of the law of precedence over the lower authorities. I think there cannot be a debate on the second aspect, that the law of precedence is applicable to all the lower authorities and to all the judicial forums, because the verdict of the Supreme Court is the law of the land. The interpretation by the Honorable Supreme Court can be changed only by a higher bench of the Honorable Supreme Court. Then, as far as the decisions, the judgments of the courts are concerned, the jurisdictional High Court judgment certainly carries overweighing power of binding force over the tribunal and the lower authorities. But if there is no jurisdictional High Court decision, then the other High Court decision, particularly when there are no contrary decisions of the High Courts, the other High Court decision will have binding force on the Honorable Tribunal as well as lower authorities. When it comes to Honorable Tribunal, the decisions of the larger benches, special benches, will be binding on the Honorable Tribunals as against the single bench, single member or division benches. When it comes to following the decision of the coordinate bench, I think Mercedes bench, the Bombay High Court is very, very categorical that even when a coordinate decision is there on a point of law and facts virtually remaining same, even if a coordinate bench finds or comes to a view that the earlier decision of the coordinate bench was wrong, then also the coordinate bench cannot decide in contradiction to the already prevailing decision. At the most, a coordinate bench may bring to the notice of the Honorable President to form a larger bench or a special bench on the points of law. Therefore, the decisions of the Supreme Court, of the High Courts, particularly jurisdictional High Court, the special bench, the coordinate bench are all law precedents and binding upon in their respective orders. And lower authorities many a times are practically not accepting the jurisdictional tribunal decisions also, maybe because of some practical limitations, because the lower authority thinks that the department has not accepted the tribunal decision, department has gone to the High Court. Now if I pass an order based on tribunal decision, then today the order will be final. Once the order is passed by the AO, 148 and 263 have very limiting aspects. This very order of the AO can be rectified only within 4 years. Beyond 4 years, he cannot rectify his own order by subsequent Supreme Court decision. And the Supreme Court decision will not come most probably within 4 years. And therefore, sometimes they have practical limitations. That if I follow the tribunal decision, department has not agreed upon the, accepted the tribunal decision, and therefore I would be better advised to take a view contrary to the tribunal decision. And he writes also sometimes, that since the department has gone into appeal, and therefore I have no alternative but to write the order accordingly. But as far as law precedence is concerned, this can tantamount contempt of court also.
Call from Bhubaneswar.
Yes, please come, please. मिस्टर विश्वरंजन, आप अपना टीवी बंद करके ऊंचा बोलें जरा.
I have a question regarding delay
Delay condonation.
I have a delay condonation. Yes, sir.
Delay condonation.
अच्छा.
Yes, sir.
बोलिए
Hello.
Please speak. Yes, sir.
Uh,
Delay
actually,
condonation, your question.
The assessee has not gone
Yes.
appeal before CIT against the order of assessment of the assessing officer. Rather, he has filed 54 rectification petition.
154. 154.
Okay.
For
okay.
rectification petition.
Yes.
But the assessor is not disposing of that petition.
Yes, sir.
Petition.
Shall I
Whether
address your questions?
Now,
Yes, sir.
the assessee can file appeal before CIT. Files appeal before CIT appeal with a delayed condonation petition
Yes.
against the original assessment order.
Getting it, sir. Should I respond?
Thank you, sir.
No, yes, sir, please go ahead.
Please.
Go ahead.
I would respond like this, that the remedy in the form of 154 application, vis-a-vis the remedy in the form of appeal, are not the alternative remedies, are not to the exclusion of each other. One can file both the petitions simultaneously also. And if one has spent his time in pursuing a rectification application only, and as I understand your question, that is rectification application was not attended to or rectification was not granted. If the rectification is rejected, certainly that may become a point of appeal, and therefore from the date of communication of the rejection order under 154, the time limit will start. But if the AO sits over the rectification application, does not decide, then also one may plead before learned CITA that I spent some time genuinely for rectification, and this point according to me fits in the gamut of 154 because it is a mistake apparent from record. But one would be advised as a matter of precaution to file both the simultaneously.
Okay, sir, please.
I entirely agree with.
Yeah, but wait, let's finish this question.
I entirely agree with GHIA Saab, and in fact the similar type of matter came before us, where the SSC against the order of penalty under section 271(1)(c), instead of filing up the appeal before the tribunal, he pursued his remedy under section 273A, that is for waiver of penalty by commissioner. And the commissioner did not dispose of his application despite several reminders to the commissioner, to the chief commissioner, to the CBDT for more than 10 years. And then after 10 years he filed the appeal before the tribunal, and as a tribunal we condone the delay because SSC bona fidely was pursuing the remedy, and therefore if SSC bona fidely pursuing his remedy under section 154 and his matter was not getting disposed of despite his all persuasion, then it can be a good ground for condonation of delay.
Correct. So quickly saying, to sum up your query, if the fact that 154 order is not being passed by the assessing officer and you omitted to file an appeal constitutes a bona fide mistake by you, because you believe that the order would be passed under 154, therefore you did not take up your remedy under, therefore you have to only make out a case saying that this was out of a bona fide mistake, it ought to be condoned and it is for no fault of mine. Please read a decision of the Delhi Tribunal on bona fide mistake in the case of HLS Asia 121 TTJ 340. That will answer your question.
Thank you. Now we come on to the next question. Sanjay from Karnataka. Okay. You can go ahead, sir, with what you were taking.
Sir, now my question, sir, is till the call comes. We were on the doctrine of stare decisis. That is, a decision has to be, or by a higher authority has to be followed by a lower authority. Now, I am coming out to a tribunal's decision. I totally agree with Mr. GHIA that if there is a... Yes, okay.
Yes, Mr. Sanjay, please. Hello.
Sir, good afternoon, everybody.
Very good afternoon.
I have got a question. I have filed one appeal for the assessment year 2009 7-8.
Yes.
Yes.
But till today, I've got no hearing from appellant commissioner.
Should I respond to your
Yes,
answer?
sir. What are the remedies
Should I
available
respond
to
to your
me, sir?
question? Yes. The time limit has definitely been provided in the law that in the subsequent financial year, after the from the date of from the year of filing the appeal, learned CIT has to decide the appeal, but that time limit is in advisory nature, and therefore you can first file the application for expediting the hearing, and at the most probably this being a very procedural aspect, you can at the most file a application with the ombudsman that because today the appeal pending of assessment year 7-8 is a very very rare and unique case that for as many as 6 years the CIT has not touched upon your appeal. Prima facie it's a very unique case.
Yes, yes.
Let's have the next question.
Next question. Yes, Mr. Pawan.
I am Pawan Kumar Agarwal from Tinsukia. My question is, what are the consequences if the assessing officer avoids decision of the jurisdictional high court on the flimsy ground that they have not accepted the decision of the Honorable High Court yet, and they have applied for special leave of petition before the Supreme Court, and they in fact make addition against those grounds?
Let me respond to this. You see, the jurisdictional high court's decision is binding on the subjects that high court has under it, which means the assessing officer is bound to follow that decision. But yes, there is a point that they have filed an SLP, they have to revive it, they have to keep it alive. In fact, this is an issue which we have raised before the board. They are concerned about it, but they say that if, let's say, the assessing officer gives relief following the High Court judgment and the Supreme Court reverses it after six months or maybe 4 years or 5 years, what is the remedy available? They are at it. But as of now, unfortunately, you have to bear with this. But the remedy is very simple, is that if the assessing officer takes note of the jurisdictional High Court decision, makes a note of it in the assessment order, he cannot make any recovery of tax. So you rest assured that the addition that he makes will not go against you in the sense that there will be no recovery, and in the subsequent appeals also that you file, they will all go in your favor. But perhaps the board is considering this issue, and if Mr. GHIA has anything to add to this.
No, I fully agree with Ajayji's views. Only thing, it will be certainly, if it is not followed, it may dent amount contempt of court also, because jurisdictional high court decision stands on a totally different footing. And Supreme Court appeal is not always an allowable appeal. There is an SLP to be first allowed, whether
Sir, what would you say to this? This is all right. No, coming back to my question, sir. Sir, the tribunal decision is there. Agarwal Sahab, this is for you. The tribunal decision is there. We cite that decision to the CIT appeal, and we say this is the legal issue which has been decided by the tribunal. CIT appeal doesn't agree. Now, can we can we file a contempt against him? Can we seek costs against that? How would the tribunal view the disregard of the CIT appeal of its order?
So far, the legal aspect is concerned, law precedent is concerned, as Mr. GHIA has rightly explained, that the decision of tribunal is also binding on the CIT appeal. So ordinarily, he should follow the same. If he has not followed the decision of the ITAT on the same point, then SSC can certainly in his appeal claim the cost to be awarded. So far contempt is concerned, it would be a very lengthy procedure, because the tribunal per se doesn't have the power of contempt. The tribunal has a power to recommend to the High Court to initiate the contempt proceedings against a person who committed the contempt of the ITAT. So that may be a very lengthy procedure. So advisable thing would be to file the appeal before the ITAT and raise the ground for awarding the cost, which ITAT is empowered to award.
Fantastic. Thank you so much. Thank you so much. Can I now hand over the proceedings to Mr. Nanda?
Thank you, gentlemen. Dear friends, you know all good things in life have to come to an end. This interactive program also has to come to an end. But with a promise from CP committee, we will repeat the part B of this program very shortly. The new committee has to be constituted and the program will be, I am recommending to the committee that the program be again taken, the areas which have been left have to be taken and highlighted for the benefit of membership at large. Thank you. Thank you so much for your patient hearing. Thank you.
Thank you.
Thank you.